SJC-10776, Commonwealth versus Ayala.
Mr. Jacobson, good morning.
Good morning, Chief Justice. May it please the court, I'm Miles Jacobson. I'm here with Attorney Michael Fellows for Mr. Ayala. It's my hope that with the court's permission that I will be able to address the court for the first 15 minutes, and I'll address the court on issues of insufficiency of the evidence and substantial likelihood of miscarriage of justice. And Mr. Fellows will address the court on an issue that affected the presentation of a defense witness. Excuse me. The issue in this case for insufficiency of the evidence concerns the identification testimony and the element of identification of the shooter. As Judge Vila said when he instructed the jury in this case, identification testimony is an expression of belief or impression by a witness. Its value depends upon the opportunity the witness had to observe the offender at the time of the offense and make a reliable identification. The issue is whether the witness had the capacity and an adequate opportunity to observe the offender. That was consistent with Commonwealth versus Rodriguez. For the sake of argument and try to illustrate the problem in this case on insufficiency, I'd like to assume that the witness had a much better opportunity to see the offender than he did. For example, let's assume it happened in the daytime rather than at night. But even in that situation, given what we know are the weaknesses of eyewitness identification and the facts of this case, there's reason to doubt the accuracy of the identification. Not just for the jury to doubt that accuracy, but objective reasons that suggest that the jury must have speculated.
Mr. Jacobson, I certainly understand the argument about the muzzle and flashing light being a factor in ID and raising questions about the ID as it relates to ineffective assistance of counsel and getting into the issue of could you really do that with from the light from a muzzle. I get all that. But how can something that wasn't in any way part of the trial impact whether or not in the record at trial there's enough to withstand a motion for required finding?
Oh, Your Honor, I'm not relying on that, on the evidence of motion for new trial at all. The question is this. We have a witness. Let's look at the evidence in the case. What's the evidence against Ayala? It consists of one witness, an eyewitness who claims that he sees the offender and recognizes his face as a person who he was afraid of earlier at the party and who had acted badly at the party. Fine. The jury, unless they're just speculating, needs to be able to evaluate whether or not the viewing opportunity was a reliable viewing opportunity. Now, what evidence do they have on which they can make a reasonable inference that there was a reason that this was an adequate viewing opportunity? Well, we need to understand what the witness says. The witness says, I don't know whether the street light was on or off. And by the way, if you look at the pictures of the street light, which are available in the Commonwealth's brief, they're available as trial exhibits, but they're also available attached to the Commonwealth's brief, you can see that the street light hangs out over the street. There's no evidence in this case that the street light or any other ambient lighting would have lit the face of a person standing on the sidewalk near that street pole or standing on the grass near that street pole. There's no evidence that that happened, and there's no argument that that happened, except now on appeal.
Isn't there an argument that, isn't there evidence that the lights were on?
Yes,
From
so
other people.
he said he didn't know whether the light was on or off.
But other people testified the lights were on.
Not at that moment in time, but at a later time when the police came and looked around, they said the lights were on,
And what time is the shooting at?
3 o'clock in the morning.
And is there any reason to believe that the lights would be different at 3 than 5 or whatever later? I mean, reasonable inference is it's dark, right? The lights are on later, why wouldn't they have been on at 3 in the morning?
They might have been, I mean, you would think if they're operating properly, they would be on, but why isn't the witness telling us who was there? The street light was on. This witness, when he looks and sees the shooter, doesn't see the shooter before the muzzle flash. He doesn't see the shooter in the street light, like in the...
Yeah, I mean, Gwen, we got a Lattimore standard, right? We have the fact that your client shows up at the party, he's angry, upset, he says he's going to light up the place, right?
Yes,
He stamps on the door, his footprints on the door.
yes.
He's gone by the witness twice in close proximity, right?
There's no doubt that the witness has a good view of the guy in the staircase, which is Mr. Ayala.
Right, no, I understand. You just have to work with all of those facts, right? Not just with the light factor.
Of course. But what do those factors tell us? First of all, a threat to commit a crime is not evidence that he committed the crime. Identity is the central issue. We can't add to a terrible ID, well, he had threatened to commit the crime. What's the motive here? The government suggests the motive must be, well, he wanted to light the place up. Well, let's look at what happened. He doesn't shoot at the building. He doesn't shoot at someone coming out of the building.
So where are the people, the victim is how close to the building when he shoots the victim?
The victim is crossing the street on the other side of a building adjacent to where the party house was. Not far, but maybe, I don't know, 30 yards away.
And is he with the woman whose pants are down at that point?
The victim is not, but the witness is. The witness is right in front of the party house because he was trying to attend to that woman. The victim was crossing the street diagonally towards his car, and someone on the same side of the street as the party house that they had left, who's standing on the sidewalk or on the grass, shoots the victim several times as he's crossing the street. Now, it's possible that there could have been the man who made those threats, but that's not okay, that it's possible.
Don't you effectively need to demonstrate that if there had been a motion to suppress that identification under essentially Rule 403, that it would have had to be allowed based on the inherent unreliability of it?
Here's the problem with that, Justice Gantz. I've thought about that question myself. And what I've thought is this. If you did not decide to dismiss the case based on insufficiency, but you do decide to send it back for a new trial, that issue would come up just as you raised it. But here's why it could not have come up. It was a surprise. There were two surprises in this case that were unfair to the defendant, and that was one of them. No one knew that the eyewitness was going to, in effect, have different testimony and say, for the first time, I saw him, his face was illuminated in the muzzle flash. No one knew that. It's very clear from the motion for new trial. The government says they didn't know it. Otherwise, they would have had to tell the defense.
I get that, and I don't quarrel with the failure of defense counsel to have made the motion, since we didn't even say there was such a motion till more recently. But in terms of our analysis of your sufficiency argument, isn't that effectively the analysis we would have to make, that this testimony is so unreliable that no reasonable jury could have relied upon it in making an identification?
No, I think that the problem in this case is actually is twofold. One is, I submit that the jury is required to speculate in this case that there was sufficient light. The jury is required to speculate that the light from the light post, which let's assume there's sufficient evidence in the case to think was really lit and on, as you have suggested, Justice Kaffer, that light would have illuminated the shooter's face, not obscured the shooter's face in shadow, which of course is a possibility, not being bright enough. No one is saying, there's no testimony whatsoever that street light or any other light shone on the area where the shooter was standing. And I submit to you that it may be why the witness decided to come up with this idea that he saw the face in the muzzle flash, because otherwise that testimony he knows is subject to questioning. Defense counsel didn't get to argue in the end, well, the streetlights, who knows about the shadow, because now shadow is irrelevant.
Should you maybe just take one more run at Chief Justice Gantz's question, though, Mr. Jacobson? Because what we're looking at on sufficiency of the evidence is not anything about something that wasn't part of the evidence.
Of course.
The ability of the muzzle to lighten
No,
the area.
I'm sorry.
I know your view is opportunity to be able to make the idea. I understand.
That's not my argument. My argument is this, and maybe you understand, in which case, double apologize for interrupting you. The jury was told, and the facts in this case were, that the face could be seen in the muzzle flash. Okay. Let's say it wasn't in the muzzle flash. Let's say it was in a flashlight. He happened to have a flashlight shone his face. The jury would have had some idea what that meant. The jury on its own, or I could see his face in the streetlight. The jury would have a way of evaluating, is that adequate? That's the job of the jury. They had to have evidence from which they could evaluate whether it was adequate.
Well, then
They
let's-
don't know what muzzle flash is, and nobody told them. The only evidence of what muzzle flash does in this case came from Sergeant Kane, testified for the government later in this case. And he said, there was a question, could you see muzzle flash? Yes, you could probably see muzzle flash at night from a .22. That was it. Nothing about the intensity, the direction, the duration of muzzle flash.
I just want you to have a chance, too, because you didn't answer the question
I'm sorry.
that the chief asked, and I'm interested in the answer. What you're saying is that there's not an adequate basis or opportunity to have made an ID because the muzzle wouldn't have created that light. Well, we look at the record on insufficiency of the evidence on the record we have, not based on these discussions on appeal or the potential expert witness. So if that's the case, isn't the chief right that the only way for this argument to work to say we're looking at the record and being in the position of the trial judge that the probative value of this evidence based on the adequacy and opportunity is substantially outweighed by the undue prejudice of an ID that's not good?
With respect, I don't think so. I think that were there such a motion, it would have or should have been granted, first of all. But on insufficiency, the question is, let me start a little bit differently. The government suggests in its brief that the mere fact that the witness says, I can see him in the muzzle flash, well, okay. Well, what do you need? Ladies and gentlemen, that's it. But we know that's not it. As a matter of law, the jury has to have facts from which it can evaluate the adequacy of the identification. If it was just it, there would be no purpose to those Rodriguez instructions. There would be no purpose to saying you really have to evaluate the adequacy of the opportunity. Why? Well, the government is entitled to the benefit of the jury's rational, reasonable inferences. In this case, that reasonable inference is this. The witness honestly believes that he saw the face of the person and it was the same person he was afraid of earlier. He honestly believes that. We resolve that in that favor. But that's all you get. The fact that he then later makes an identification, sees a photograph, that's the person on the staircase. And he even says, oh, I made a mistake about the height of that person. He's not as tall as I said he was to the police, because after all, I saw him on the staircase. Who's he talking about? The guy on the staircase. This case comes down, there's no other physical evidence that stays in place. I'm going to stop because my time is up, but thank you very much.
All right, thank
Mr. Fellows, will take.
Mr. Fellows?
Chief Justice, Your Honors, Michael Fellows for Mr. Ayala. I'd like to address briefly, mostly to try to clarify the issue of dual sovereignty between the feds and the state here and the defendant's witness. The defense witness was acknowledged by everyone to be a confidential informant for the Western Massachusetts Gang Task Force. And starting before trial, when he found out that this witness was a CI, defense counsel sought to get all kinds of records, sought to subpoena records about her involvement, all of her involvement, to get the guidelines and all of that sort of thing. But the crucial question by the end of trial, it seems to me, is that once this witness testified, she testified first, sort of, that she was a confidential informant. She said she had gotten some information, some money from the feds for giving information. But then on cross-examination, she said that she had only been paid once by the federal government, and that only in relationship to money that she had received for giving information about someone shooting her. Now, there was a lot of conversation after this witness testified, but one of the things the prosecutor said was that she found that her testimony mind-boggling. She was confused that from the basis of this testimony, it seemed like she was saying she was not a confidential informant, when, in fact, she was.
When you say she's a confidential informant, she's not a confidential informant in this case, right?
She's not, no.
And doesn't that affect all of this analysis? Because this is not a joint investigation, right? It's a Commonwealth investigation. She's not a CI in this case. She's a CI in other gang-related activity. It seems like this is a different case than a number of the earlier ones, isn't it?
Well, first of all, I don't think so. In Donahue, which the Commonwealth cites, and in Bonnet, I don't think that it's clear in either of those cases that those were joint federal state investigations that led to the convictions that were being discussed.
I thought it's pretty clear that it's a joint investigation in Donahue, isn't it?
I don't recall it that way. Certainly, it's not clear in Bonnet that that was the case.
Yeah, Bonnet, it's not clear, but it's the other cases, all the earlier cases, wasn't it clear that it's a joint investigation?
Well, I think that what the Commonwealth points out is that there are 4 factors that the court should look at, and I don't disagree with those. And one of those was it a joint investigation? But the first factor is, was it prejudicial to the defendant? And that's what I'm trying to get to here, is that this was highly prejudicial to the defendant. Because
Why is that?
Well, because she is the only person who testifies differently than the Commonwealth's witness. She says that she knew this person, that she saw him, she saw that he was upset, she tried to calm him down with friends, she saw him leave, and that he was not there at the time of the shooting. Now, the jury would have been entitled to accept that testimony, but by the end of her evidence, she's undercut herself so much, whether because she's afraid, as she says, that the government is going to retaliate against her by not paying her, or for whatever reason. It appears objectively that she is not a confidential informant, and everyone in the courtroom, including the judge, knows that she is, and that information is never corrected to the jury, because the government, the federal government, will not allow anyone to come in and testify that she is a confidential informant, that she has worked for them for a period of time. If you look at some of the questions that the trial judge or the trial attorney wanted to ask, was she ever shot? Was she paid for giving information about that? Was she paid on other times?
Generally, this issue comes up when this person is testifying on behalf of the Commonwealth, and the purpose of knowing that is to be able to say, well, you're testifying favorably to the Commonwealth because someone's paying you to do that, and you have a relationship with them, and you need to keep them happy. But here she's testifying contrary to what the Commonwealth is presenting. So the fact, are you saying that if the jury knew that she was a CI, they would say, well, the feds think she's reliable, therefore you should think she's reliable?
Absolutely not, and I think that's the wrong argument. I think that's the argument.
What is the right one?
judgment.
The right
That-
one is that she's backing away from a better story because she is fearful of teeing off the feds who are continuing to pay her? Is that, I'm trying to figure
I
out.
think the argument is simply this, that she testifies, it seems, that she's a CI, then she testifies that apparently that she wasn't, and that she should have been allowed, or the defense should have been allowed to present corroborative evidence to show that in fact she was a CI, so that her testimony then becomes more believable. It's not vouching,
And
it's corroborating.
If you know everything, if you know everything now that you know, what argument do you make in closing that was not made at the time of trial with regard to her testimony?
What argument do I make?
I mean, what's
What
the,
argument does the defense attorney make?
if you had gotten all this information, what argument, I'm trying to figure out what you could have argued in closing that is different from what was already argued in closing about
Well,
her
what I was
testimony.
more concerned about in closing, I don't know that I looked at not recently anyway, defense's closing, but I looked at the prosecutor's closing, and the prosecutor twice makes comparisons between the government's main witness and this CI, and says, look, you can see what he says, and he's very reliable, but you can take her for whatever she's worth, if anything. And I think there's an implied disparagement, and it turns the argument, instead of should you believe this person, did he have an adequate opportunity to view it, to who do you believe, him or her? And she is confused at best and probably is not telling you the truth. And when we have evidence that the things she was saying, some of the things she was saying were true and that could have been presented to the jury and that was not allowed, then I think that creates a fundamental unfairness in the case,
Meaning
one that
that-
was exploited a little bit in closing argument.
I'm just trying to figure out, because, so that she was paid on more times than she testified. That would show what exactly? So the missing pieces of information are that she was not just paid once, but paid multiple times.
That she was working overtime as a confidential informant, that she was not just, what came out of trial is she was just paid this one time because she got shot.
And that would
it's not
show-
even clear that she's a CI at that point at all, and that's what the prosecutor says afterwards. She doesn't sound like a CIA there, but the Federal Bureau of Investigation has told me she is.
And that would show from a defense's perspective that she's more reliable? I'm confused.
It would rehabilitate her to her testimony after she has,
Showing that she's lying would rehabilitate her testimony?
showing that she's,
Lying about how many
I
times
don't think it
she's
shows
been
that she's
taken?
lying. I think that shows that she's that she's confused, or that the testimony is confused by the end of it. And I think the evidence would clarify exactly who she was and whether she said she called them the night that this happened. There should have been testimony that said, did she call you? Yes,
But
she did.
they provide evidence that she has told them that there's Torium, there's a third party possibility, or that someone is left in this red car, right? That's all been turned over to the defense counsel, who's deposed her, right?
Right, and that is one of the things that the judge focuses on, but I think that it's not relevant to the question of whether the defendant should have been able to put on evidence that she was in fact a CI. I know it seems like it's a small piece of evidence, but it's crucial to her testimony because I think it seems kind of inherently implausible from the very beginning. If you're just sitting on a jury and somebody says, well, yeah, I'm a CI, I've got this nickname, I got shot and I got paid for giving information. And then she kind of says, well, no, I just got paid for getting shot. That she becomes an inherently non-credible witness. And that was unfair because those facts are true and they were known to the judge, to the prosecutor, to the defense counsel. Everybody knew it and the jury should have been allowed to know it.
I have the same confusion that's led to some of these questions, so I'm just going to ask the same question in a different way. If you had the file from the feds, would the information that would have been offered in evidence have been offered to impeach NF or offered to corroborate?
Well, we don't have the file. We never got the file. So I don't know what would happen if we got the entire file. We might know more about the incidents that happened that night than we did. What I do know is that at the end, defense counsel asked to call an agent, Condon, and ask him specific questions. Was she a CI? When did she work for you? Was she working for you that night? And I believe that that evidence would have been used to corroborate her testimony, not to impeach her. He said he didn't want to impeach her, to corroborate her testimony that she was, in fact, working for them at the time, and that some of what she said that seemed either slightly unbelievable or confused was, in fact, true.
Okay, thank you, Mr.
Thank you very much.
Mr. Shepherd-Brick, good morning.
Good morning. May it please the court, David Shepherd-Brick on behalf of the Commonwealth. I would start with the confidential informant issue because whether or not the Commonwealth had this file in its possession, it's not exculpatory evidence. The trial judge said it's relevant, though not per se exculpatory. What it does is vouch for the credibility of the confidential informant. And certainly when the Commonwealth suggests that the government has special knowledge, as this court said in Chiampa, by which it can verify the witness's testimony, reversible error may occur. So what I would suggest is, even if the Commonwealth had it in its possession, which I do not concede, it's not exculpatory, and the trial judge was well within his discretion in saying, no, I'm not going to let you put this witness on and have him vouch for your witness.
I'll be honest, after we just heard, I'm not exactly sure how it was going to be used, but when I was reading the briefs, I thought their argument was going to be that the CI changed her testimony because she upset her handlers in the FBI, Mark, whatever his name is. And if they knew more information about her relationship, that it wasn't a one-time payment, that would have been used to show that she shaped the testimony some. That was my understanding of that. If that is accurate, and that's an assumption, how does the vouching argument save it? Because it's really not about vouching, it's actually about pressuring.
Well, first, and while I agree with your description of what the argument was, the evidence at best was that the Special Federal Officer Condon told the eyewitness before the deposition to tell the truth, and that according to an affidavit that she filed, that one of her superiors was displeased with her involvement in the case. I think that's really the extent of the testimony. So the leap to she was pressured into changing her testimony, I don't think the defendant has made that connection. Because at the end of the day, the defendant still hasn't identified what information he didn't have. I mean, he knows she's a confidential informant. He was able to depose her. He was able to ask her questions about her payments. He was able to get an affidavit from her saying that her federal handler was unhappy with her testifying in this case. He didn't attempt to elicit that testimony because, as he was very clear from the beginning, he wanted to have the special federal officer get on the stand and say, this is our informant, we use her all the time, we've paid her all the time, and therefore that the jury should find her credible.
What's your understanding of, in this case, there's no indication that the CI there's no joint investigation here, right?
There is not, and I would point specifically, Judge Roop found in it's the September 26th transcript, 2008, at page 21, she specifically found that it was not a joint investigation.
So if it's not a joint investigation, what is the obligation of the Commonwealth there? I understand when there is a joint investigation, but this case seems different than the others, right?
It is, because in all of the other cases, there is, Bonnet, it's unclear.
Right.
But in all the other cases, it's clear that it was a joint investigation from the outset. Here, it's very clear that it's not a joint investigation. The eyewitness, the confidential informant testifies that she called her federal handlers that night because she knew a couple of police officers, so she called them, and she provided them with a statement that they put in the FBI file, and they also provided to the Springfield Police Department.
By the way, did you check the briefs, and I'm not expecting you to have done so, but in Bonnet, did you look at the briefs to figure out whether there was a joint investigation? Because I know the footnote's unclear in Bonnet.
I did not read the briefs themselves. The footnote, I rely on what the footnote says, that it's just unclear.
I could turn you to some of the evidence in this case. I mean, this is a hard case on appeal. It's a hard case at trial because we have an eyewitness, single eyewitness at a single moment in time, seeing somebody who we fully expects to see, which based on the literature of the eyewitness testimony is sort of the riskiest of all eyewitness IDs. So speak to me a little bit about what the evidence was about how far away the defendant was from the eyewitness at the time of the shooting.
So the eyewitness testified that he was walking across the street when he saw the shooter. The Sergeant Rowland testified that from curb to curb, the street was about 40 feet across. So, and he said he was coming directly out of the house, and the shooter was, based on the location of the shell casings, standing to the left of the street light. So the suggestion is about 20 to 25 feet from, putting all that together, that the eyewitness is about 20 to 25 feet from the shooter.
And when we look at the record, I know you have the officer who at 4:30 a.m. says those lights were on. Mm-hmm. What will the evidence be as to the how lit that 20 to 25 foot area was?
Well, it's interesting because the eyewitness goes, after the incident in the stairwell, he goes up onto the porch and he sees the defendant pacing out front, very upset. So he, again, is clear that he can see someone down on that sidewalk. The confidential informant also says that she was on that porch and saw the defendant downstairs and she was able to see him in that area. So we have two people saying that they can identify the defendant walking in front of the party house. Beyond that,
Is that the same place where he was shooting from, or is that a different location?
so the shooter was standing closer to 338. That's where the light post was in front of 338. This is in, the party was at 334, 336, which is a multifamily unit. But it's clear, one from the pictures, it's a very small area. And besides the fact that the eyewitness says that he could see the face, and I don't think that the testimony goes as far as the defendant wants it to. He says he couldn't remember whether the light was on. I don't think that's the same as saying what light wasn't on. And then you have all of the testimony from Sergeant Rowland, who says not only is that light on, but there's lights across the street, lights down the street, lights from the store at the corner. All of this lighting information at 4:30 in the morning, which is when he said he arrived. So an hour and a half after. There is also a flood lamp that can be seen in one of the photographs that is included in I believe it's included in the Commonwealth's appendix, that is on 338 and is facing directly towards where the shooter would have been standing. And it's still on at that point. I think he said 6:30 or 7 is when they started taking the photographs.
Now, the briefs say nothing as to what the other evidence in the case was, which may mean that there was no other evidence, but let me ask, he was arrested. Mm-hmm. Any evidence with regard to what was said at the time of arrest or
no
search of his person? Was there a search of his home?
Not that appears in the record.
Nobody sought to search the home to see if there was ammunition that was consistent with the ammunition used?
I don't know.
But there's nothing offered at trial with regard to any of that.
I don't believe so, no.
So we're left essentially with his conduct at the party plus the eyewitness account.
Right.
That's the entirety of the case is based on that.
Right. But, it's not entirely based on the eyewitness's testimony because his testimony is corroborated both by Haynes, who was the bouncer downstairs, at least in terms of the incident in the stairway.
Right. I think there's no meaningful dispute that he was the person who did that at the party.
Right.
And no meaningful dispute that he is the person who everyone would have expected would be doing shooting. But that's also the source of concern, is that when people see somebody they expect to see, it becomes a problematic eyewitness ID.
Right. And that's
Not quite sure what we're supposed to do with that.
Well, it was actually presented to the jury through closing argument. Defense counsel pointed out to the jury, you know those times when, you're absolutely sure that you saw something a certain way, and then it turns out you were completely wrong. Maybe he was just remembering, I don't remember his exact words, but he was talking about basically the idea of unconscious transference that was brought up in Dr. Summers' post-trial testimony. So that issue was before the jury, and I think it's within the realm of common sense and life experience that, we all know that sometimes we see things that didn't actually happen the way we thought they did. So I think that was a reasonable argument to make to the jury. I don't know that the post-trial expert would have really made that any stronger. I would specifically suggest that the post-trial expert was, Dr. Summers, was quite a good witness for the Commonwealth. I think I would have called him at trial. He spoke to the positive aspects of this identification almost as much as he spoke to some red flags, as he called them. He said it did not appear to be cross-racial. The eyewitness's age did not raise a red flag for him. He had a prior opportunity to observe, the eyewitness had a prior opportunity to observe the defendant in a moderate stress environment, which is, he said, ideal for identification. So he was familiar with the defendant, making it more likely that the later identification was correct. He also testified that the police used excellent procedures, including sequential photo arrays, at least 6 filler photographs, and informing the eyewitness that the perpetrator might not be present. So I think you have, under the 33E question, I think you have all of that to show that this was really a pretty solid identification. And the defendant can say, well, maybe it was a little dark, but I don't think he has enough to sort of show that there was such a chance of misidentification.
Now, in the motion for new trial, but for some reason not on appeal, the defendant said that counsel was ineffective for failing to ask for what he would have been entitled to, which is an honest but mistaken jury instruction. For some reason, it's not mentioned in the appeal. I mean, we've had that before. What significance do we attribute to that realistically in the 33E context?
I think because, again, defense counsel spent a good deal of his closing. I believe he, in fact, said, the eyewitness isn't lying to you. I don't think he said, I don't think he's gotten up there and said something he knows to be false. But you have all of these things going on at the party, and you have all of these problems with his testimony such that he was mistaken, that he confused the two. And so I think it was before that exact issue was presented to the jury.
But that's the momentum that you like from a closing. You say it in the closing, and then the judge says basically the same thing, referring to the law and the instructions. So that only makes it tougher that there was no honest but mistaken ID instruction, doesn't it?
I don't think it makes it tougher. I think that certainly, as the motion judge ruled, he would have been entitled to the instruction. But because it was put before the jury, I don't think you raised to the substantial likelihood of a miscarriage of justice where it was put before them quite forcefully. I can address the other post-trial experts. The muzzle flash experts are interesting. One, I suggest that the trial judge would have been well within his discretion to exclude them. They all admitted that they did not attempt to recreate the lighting conditions at the scene at all. So to have someone get before the jury and say, you can't see someone in muzzle flash alone, would really serve to confuse the jury, because that's not the lighting situation that was presented. But even if you say, okay, well, but he could have, within his discretion, allowed them in, one of the ballistics experts, Donis, testified that in his experience, someone could see a face in ambient light and see the muzzle flash going off and mistake the source of the light as the muzzle flash. So you don't really have, he's not impeaching the testimony, he's in fact explaining why the witness might have been mistaken but still made a proper identification. I would also point in Dr. Courtney's testimony, and this goes to whether or not the shooter could, the eyewitness could see the shooter. He testifies that both the shooter and the victim, he believes based on the bullet trajectory discovered at autopsy, were moving at the time of the shots fired. And he said he used a 6-inch barrel because accuracy in that type of situation is difficult for anyone. But having a longer barrel certainly makes it a little bit easier. But you have someone who has fired at least 5 shots, there are 5 shell casings, and hits the victim 3 times. So in these experiments, the shooters could not see the target. So when you have a shooter making a very difficult, what the expert says is a very difficult shot, it sort of strains credulity to say, well, but the eyewitness who was standing in looking right at the shooter couldn't have seen him. And finally, the PTSD expert, I would suggest the trial judge was well within his discretion in excluding that particular testimony. It was even if you look at the post-trial affidavit, it's completely speculative. He says it may have affected the ability of the witness to perceive, that it had a possibility to. But we don't have any objective evidence that the eyewitness was suffering from any symptoms that night. No one testifies that he was acting strange, that he appeared out of sorts. There was absolutely no evidence of that, and he denied that he was having any issues that night. So without any objective evidence that he was suffering any symptoms, in addition to the fact that the court-appointed clinician interviewed him at the time of trial and said, I don't see any symptoms manifesting themselves right now. And the trial judge pointed to that and said, someone who's interviewing him right now is saying he doesn't see any symptoms, so I'm not sure how someone's going to go back in time and say that somehow he wasn't able to perceive the events. If there are no further questions,
Thank you.
I'll rest on my brief. Thank you.